So with that scenario, my lord, an independent observer, a fair-minded, reasonable person would definitely conclude that one cannot be impartial. It's the reason, my lord, the proceedings of this nature are structured in such a way that the assessors, these ones, they are not lawyers, they are laymen. These three assessors, they are ordinary people picked from downtown. So how do they perceive that situation, my lord? That's what is a vision under the law. That will you be fair and just in deciding the fate of the accused persons? When actually they are putting this sort of go to the point whether the matter should be referred to court. Yes, my lord, that's where I'm headed. That's where I'm headed, my lord. This is the matter. And then what's going to be the question whether this matter should be referred. My lord, that reinforces my submission that court cannot be fair. That's okay. That reinforces my submission. These are the issues, my lord. The issue before court raised and framed and proposed by Mr. Kaipaya. It's the one I want to pay in court. My lord, that is the spirit and the letter of Article 28. Article 28 of the Constitution. Ready together with the Article 44, which is a non-irrevocable right. This is the issue to be now interpreted by the Constitutional Court, my lord. Whether indeed there is a likelihood of bias on your part under the circumstances. This is a matter to be interpreted. Not that actually you are biased. Let's distinguish that. Not that you have demonstrated actual bias, but is there a likelihood of bias on your part under the circumstances? That's the point that was made, and the point I'm emphasizing my own. And this is what is envisaged under Article 28, when the Constitution talks about an impartial judge or court. It's about perception. That's the point I was emphasizing. And that cannot be determined by this honorable court, because that's what the state was seeking, that you pronounce yourself on this matter, that whether there will be a likelihood of bias on you. It's not up to you, my lord, now to sit in your own matter. So, my lord, it's our prayer that you put all these matters into consideration and forward the matter to the Constitutional Court. The issue as to whether this court has received, or actually the state has received, a copy of the complaint or not, has been substantially addressed and answered by Council Kalipala. But I'll add one thing, my lord. So on record, my lord, in the course of the hearing of this matter, when the matter was being raised by A1 himself, attempts were made to supply with a copy of the court of that. The accused person, Dr. Besigye, volunteered to submit his own copy. And the court said no. The court declared that no. Please retain your copy. There are mechanisms court will use to get its own copy. The state was interested in it, it was available. But they never expressed interest in it. So we retain a copy. But the fact is, my lord, what is not in dispute is that there is a complaint before the Judicial Service Commission. I mean, the Judicial Service Commission. It's not in dispute. And indeed, from the record, court indicated that that matter is in existence. Court is aware of the existence of it. It's not aware. It's not in dispute. Finally, my lord, the option is talking about we have to file a substantive petition. Cannot be used as a bar for this court to invoke its powers to refer this question to the Constitutional Court. In the wisdom of the CADs who promulgated the Constitution, under Article 137, these options were considered to be necessary to be enshrined in the Constitution. So all these imperatives were put into consideration when they were promulgated the Constitution, under which circumstances you invoke which particular provision. So in this particular case, clause 5 of Act 137 is the most appropriate when a matter has arisen in the course of the proceedings. What do? You seek for an adjournment to file a petition? No. The reasonable thing to do under those circumstances is to move the trial judge to forward that question for consideration by the Constitutional Court, which we are doing. So we reiterate our prayer, and do so.
Fe aba Fabrication Media Uganda Limited tusangibwa Bugolobi ku Kinawataka Road kunya okulinaana Tree Shade Nursery and Primary School nga fe bakafulu mu kwocha mu kudesigninga nokola buli kimu gambanga branding, concept development, interior branding, wall branding, okutunga engoye zonna ez'amasomero, ez'office, embroidery ng'olwo tutunga ku lugoye ne tuteekako design yonna oba akafaananyi konna nga tukozesa wuzi, signage printing, promotion material eza buli ngeri, tent and activation tables, gondola fabrication ne 3D designing, eno nga ya computer, screen printing, material fabrication, van and vehicle branding, product display units nga buno bw'oteekako ebintu byo mu supermarkets. Janguko Fabrication Media Uganda Limited wano e Bugoloobi ku Kinawataka Road kunya. Okumanya ebisingawo tukubire ku ssimu zino wammanga ku 0777 44 26 9 oba ku 0701 04 69 62. Tusanyusa okulaba era tujja kolagana nnyo naawe.
Session number 335 of 2025, Uganda vs. Kano, retired Dr. Kizza Besigye, Adekwe Ntare, and Captain David Olam.
That's true, my lord.
And Richard for A1 and A2, and Martha Karua, Senior Counsel.
Proskovia Kunihira, Ivan Boy,
Ivan Boy,
Katoto Musime, and Kakuru Tumusime.
That is the persons. Count 1 is prison. Count 2 is prison of prison. Count 3 is prison of prison. All under penalty of act. That is the persons were charged in Nakawa Chief Magistrate's Court on the 21st February 2025. From court report of the lower court, the accused persons were committed to High Court on 29th May 2025. Thereafter, from the lower court file, that is file number 8 of 2025, the file was forwarded to criminal division on ENQUIRIES on 27th June 2025. From the record of criminal division, the matter was eventually allocated to the trial judge on 2nd of July. When the matter came up for scheduling and pre-taking on 8th October, A1 was given an opportunity to raise his concerns orally in open court. And from his concerns raised, he raised 2 issues for court's determination. The 2 issues captured by this honorable court, number 1, that this court has no jurisdiction and that the file should be transferred to ICT. 2, that the trial judge is incompetent or biased based on the ruling made in the application for mandatory bail, and hence the trial judge should recuse himself from hearing this matter. Literally, those were the issues raised by 1. S3 raised an issue his identity. I proceed to consider the submissions made by the accused persons themselves. In summary, A1 challenged the court's jurisdiction, asserting that Nakawa Chief Magistrate's Court committed the accused to ICD on May 29th, 2025, not criminal division. A1 wondered why they were in criminal division. He submitted that this was a deliberate to prolong their detention. The accused further stated that they have since filed a formal complaint to the Judicial Service Commission seeking removal of the trial judge from the office of the judge. A1 prayed that original file number 8 of 2025 from Nakawa, which is now session number 335 of 2025,
abalungi abatuuliriza era abatulaba olunaku olwaleero tuchaddeko ewa Sheikh Asiraf Dembe.
Sebo nsanyusa okubalaba. Amannya agange nze Sheikh Asiraf Dembe akola ku bizibu by'enjawulo. Omuntu singa aba alina ebirwadde musomereddwa tunywa amazzi ga lukuya nga bw'obadde ogalaba, tugenda abantu ku kyoto ne twokya emizimu emibi egibabaamu n'okulomba edduwa. Abantu singa abeera ng'ali wano atuuse sobola okumulombera edduwa, ne waba atatuuse nga mpadde amannya ge naye ng'ali wala. Naneetaase kale enamba yange yeeno eri 0701763711. Nammwe bannyinaffe abali ebweru oyagala okuba nti oyagala okulombera ku ddwa ng'olina ebizibu viza zibuze amaka gakolongotana sente zikola zimpita mu ngalo ojja kumpeereza ekifaananyi kyo n'amannya go ebyo byokka bijja kummala nja kukulombera edduwa ojja kutereera. Olunaku olusembayo mu mwezi mba n'edduwa ey'awamu ffenna n'abalwadde bange abakadde n'abapya. Salaamu alaikum warahmatullahi wabarakatuh.
Application for mandatory bail, and hence the trial judge should recuse himself. A1 submitted that the trial judge is incompetent or biased, and A1 based on his grievances on the ruling of mandatory bail, where the trial judge denied him an A2 mandatory bail. He submitted that the trial judge ignored political documents relating to their illegal detention in general court-martial. He requested that the trial judge recuse himself from handling the matter. Issue number 3 raised by S3 relating to identity. S3 submitted that the person charged in the indictment is different from him, that even if they share the same force number and same rank, the names and the age are different. S3 went ahead to state his proper identity. He prayed that the charges be dismissed against him. Now go to the reply by the state on issue 1, 2, and 3. In reply, Mr. Birivumbu, Chief State Attorney, submitted that wording in notes to accused persons attached to the indictment stating that, I quote, that the accused persons will be tried at the session at ICD was a typo error, and it was supposed to read at High Court of Uganda, Kampala. He further submitted that prosecution had taken note of the error, and prosecution was waiting for an opportune time when the accused person had ready to take leave, and he would make an application to have indictment amended under section 51 of DIA. The Chief State Attorney submitted that ICD is a specialized division designed to handle cases of international crimes, among others, but not treason. He submitted that the charges the accused are indicted with fall under the jurisdiction of criminal division. He prayed that the matter continues at criminal division, and there is no reason to warrant a transfer to ICD since the file is properly forwarded. In his reply on the issue of alleged incompetence and bias, incompetent or bias, the state stated that prosecution has not detected any sign of incompetence or bias on the side of the trial judge. He further submitted that the alleged petition against the trial judge at the Judicial Service Commission is not a bar for a judge to handle this matter, which was properly allocated to him. He stated that in any case, the Judicial Service Commission has not brought the petition to the knowledge of the trial judge to stop him from handling the matter. In reply to the issue of identity raised by S3, the State Attorney submitted that the issue can be dealt with by making an application for amendment to cure the issue of identity. In rejoinder, the lawyers of the accused persons made submissions on behalf of the accused persons, stating that the prosecution had raised issues of law that needed to be addressed by advocates. I have put into consideration all their submissions, which are on court record. But briefly, I I will summarize their submissions in rejoinder on behalf of the accused persons. Issue number one, they are rejoined on issue number one. This court and that the file should be transferred to ICT. The council submitted that there is an order of committal from Nakawa Chief Magistrate Court forwarding the file to ICT, but the file was snatched and brought to criminal division. That the order of committal was for ICD, and the question is, how did this file come to criminal division? Council submitted that divisions are different, and the processes, procedures, composition of ICD differ from that one of criminal division. Council contended that this court is acting illegally by entertaining the matter, since criminal division has no jurisdiction to do so. Council stressed that the indictment from Nakawa Court was very clear that the accused were to be tried at a session at ICT. That it is not right for the prosecution to state that there was a typing error. Council admitted further that the offences of treason against the accused persons were committed cross-border, and since ICD has a jurisdiction to try cross-border crimes, the accused persons should be tried on ICD. In regard to incompetence or bias, counsel submitted that fairness is an issue of perception in the mind of a reasonable man. That justice must not only be done, but must also be seen to be done. Counsel submitted that the accused persons made a complaint to Judicial Service Commission for removal of the trial judge from office. Hence, the trial judge did not continue handling the matter. Further, counsel also referred to the ruling in the application for mandatory bail, where this honorable court declined to grant A1 and A2 mandatory bail. Yet, in their view, they had qualified for mandatory bail and stated that this amounted to incompetence or bias, which compromises the accused's right to fair trial. In rejoinder by counsel for S3, counsel for S3 submitted that the issue of identity was raised in the lower court, but the same was ignored. Counsel referred to the case of Essimu versus Republic, where a court of appeal quashed the decision of the lower court based on the failure to properly identify the accused person. Counsel prayed that this court be pleased to strike S3 of the indictment and order for immediate release. I will now proceed to the determination of court on issue 1, 2, and 3. Issue number 1, that this court has no jurisdiction and that the file should be transferred to ICT. I have had the opportunity to scrutinize the entire lower court record of criminal case number 8 of 2025 from Nakawa Chief Magistrate's Court. This case number 8 of 2025 is now session number 335 of 2025. I have also looked at the history of this matter even before committal. Upon looking at the history of this matter, there are various applications arising from the same case, that is case number 8 of 2025. A1 and A2 filed criminal application number 113 of 2025. This application for bail was arising from Nakawa Chief Magistrate's Court case number 8 of 2025. This application was filed on 27th February 2025, when personally, as a trial judge, had not been transferred even in criminal division. This application for bail in criminal division was handled and disposed of by my sister judge, Justice Comfort Kanye, on 11th April 2025, when the trial judge was not yet in this division. A1 and A2 further filed another application for bail. This is bail miscellaneous application number 282 of 2025. This application for bail was filed on 22nd April 2025. This bail application also arises from the same case of Nakawa, number 8 of 2025. This application equally was filed in the criminal division, and this application for bail is still pending before this honorable court. The accused person, A1 and A2, still, I noticed that they filed an application for revision in the criminal division. This case for revision was arising from the proceedings of Nakawa Court, the same criminal case 8 of 2025. This case for revision has since been withdrawn from criminal division. A1 and A2 went ahead and filed the miscellaneous application number 399 of 2025. It was filed on 28th May 2025. This was an application for mandatory bail. This application was equally filed in criminal division. It was heard and disposed of by this honorable court in this division. All these applications, my view, filed in the criminal division show that the accused person and their lawyers knew that this was the right court or right division with jurisdiction to grant bail. And all these applications on their own voluntary accused and counsel, they filed these applications arising from this criminal case of Nakawa, number 8 of 2025, now session number 335 of 2025. In addition to the above finding, I have very carefully looked at the committal proceedings in Nakawa Chief Magistrate's Court. Upon perusal of the lower court record of Nakawa, that is case number 8 of 2025, when the Chief Magistrate Nakawa was committing the accused persons on 29th May, court stated, I quote from the proceedings, that in the indictment and summary of the case is read to the accused persons, and the accused persons are hereby committed by court for trial. In my view, criminal division is a division of high court. It is also my view that criminal division has jurisdiction to handle cases of this nature. The lower court record also shows that criminal case number 8 of 2025 was forwarded on ENQUIRIES on 27th June. And when this file was forwarded on ENQUIRIES on 27th June, the file was officially allocated to the trial judge on 2nd July. Further, the Chief Magistrate Nakawa, according to the court record, the Chief Magistrate Nakawa wrote a forwarding letter to the Deputy Registrar Criminal Division. This letter is dated 15th July. It is available on court record. This physical letter was forwarding the physical file number 8 of 2025 Criminal Division. All these developments show that criminal case number 8 of 2025, now session number 335 of 2025, was properly forwarded to criminal division after committal. This court is not aware of any registration number of the same case at the registry of ICD. Or court is also not aware of any other forwarding letter from the lower court to the registry of ICD. This has been claimed by accused and their lawyer to suggest that there are other documents forwarding the file of ICD. But if any, there is no document that was provided to this honorable court to show that the same case number had been forwarded to ICD and registered to ICD. Also to mention that the accused persons are charged with offences of treason and misprision of treason. This division, criminal division, has jurisdiction to try the same and has been handling other similar cases in the division. It was my considered view that the turnaround by the accused persons to allege that the criminal division of the High Court hijacked the file from ICD and of which it lacks jurisdiction to try this matter is a mere afterthought and a deliberate move which I cannot at this stage tell the reason. So in the view of the above, I find that this file number 8 of 2025, now session number 335 of 2025, and the accused persons are properly before the right court. I will now go to the issue of the trial that the trial judges promise they should recuse from the trial. I will proceed to consider the issue of incompetency and bias and subsequent request for recusal by accused. I have looked at the grounds for recusal in the practice directions. I put them down. I have looked at other authorities for recusal and the tests in those cases. The same are provided here. But I will now proceed to this instant case. The basis for allegations of incompetence or bias stems from the ruling in an application for mandatory bail. That was application number 399 of 2025, where it is alleged that court ignored political documents in relation to A1 and A2's illegal detention in the general court martial and denied the mandatory bail to the accused persons. It is my considered view that the application for mandatory bail, which was referred to, was considered on its own merit, based on the facts and the law relating to mandatory bail. The accused persons cannot use the decision of the court for denial of mandatory bail to impute incompetence or bias on the side of the judge. In any case, throughout my practice as a judicial officer, a court can deny bail today on circumstances at the time, but grant bail at any stage at a later stage. So, denial of bail, the first trial of denial of bail, doesn't mean incompetence or bias or that the judge will never grant bail. It is not proper for litigants to use decisions which are not in their favor to make false allegations of incompetence and bias. Where parties get decisions that are not in their favor, like it was in the application for mandatory bail, the remedy and procedure of challenging such decisions are provided for under the law. But it's not fair to hide under allegations of incompetence or bias. The accused person's father claimed that they made a complaint against the trial judge in the Judicial Service Commission petitioning his removal from office. It is my view that the said complaint lodged with the Judicial Service Commission is not a bar or a stay of proceedings, or cannot be used for recusal. Whoever wants to prevent a judicial officer from hearing a certain case would simply lodge a complaint with the Judicial Service Commission, which will cause absurdity. I do not find any ground for recusal based on allegations of incompetence or bias. It should be noted that this court is a temple of justice, which upholds the constitutional principles of fair trial and natural justice as provided for under Article 28 of the Constitution. There is no way whatsoever this court can bypass the constitutional provisions and undermine the rights of the accused persons to a fair trial. This fair trial, indeed, as submitted by the lawyers, it is provided under the Constitution, and this court is supposed to uphold such a provision. I will now go to issue number 3, which was raised by S3. This is an issue of identity, that he is not the person indicted. That though they have the same post number and rank, the names and age are different. It is my view that this issue can be sorted out during scheduling before pre-taking, but not at this stage of many applications. In the final result, this court makes the following orders. 1. The application by the accused persons to transfer the file to ICD for lack of jurisdiction is dismissed. The application for recusal based on incompetence and bias is also dismissed. The issue of identity for S3 will be sorted out during scheduling before pre-taking. 4. I direct that this case, main case, be fixed for scheduling and pre-taking. I so order.
Nze Hajji Ashraf Simwogerere, omuwandiisi ate era omuzannyi w'emizannyo. Mu bitabo by'empandiika bikwatagana ku bulamu bwaffe obwa bulijjo oba nga social, political and economic. Oyinza okusoma ebitabo byange nga otusinkana ku WhatsApp yaffe eri 0756 12 65 15 nga osobola okusasula omutwalo gumu n'ekitundu buli mwezi. Waliwo comments oba emitwalo 2 nga omutali comments. N'awalala oyinza otusinkana ku Amazon ku Simwogere Ashraf Kindle. Nkwaniriza nnyo otusinkane, era n'ebitabo byaffe osobola bifuna hard copies okuva ku Mukono Bookshop oba okulagiriza ku WhatsApp namba eyo oba enamba yaffe eyo gye nkuwadde. Nkwagala nnyo.
Our clients and my colleague Ernest Kalibara will communicate to the court.
while ago. They have been instructed by the accused persons to the Constitutional Court. My Lord, the instructions we have emanate out of that ruling and Article 28, Sub-Article 1, and Article 44, Paragraph C. 28, Sub-Article 1, and Article 44, Paragraph C. Of the Constitution. My Lord, the gist of this application is that in these proceedings, an issue requiring interpretation of Article 28(1), 44C, 28(1), and 44C has arisen. My Lord, in its ruling, the court conceded that there is presently a complaint pending against it before the Judicial Service Commission. And concluded that the pendency of such a complaint is not a bar to this case proceeding, neither can it be used for recusal. My Lord, the grounds of that petition are for the Judicial Service Commission to determine they are not for determination here, but that complaint was made by A1 and A2.
and is seeking the most severe outcome possible against a judicial officer. My Lord, it is seeking the removal of your Lordship. My Lord, in those circumstances, and regardless of the history of the committal proceedings, the applications, and so on, that your Lordship has observed or referred to, the question that remains to be answered is whether this court can continue to be an independent and impartial court within the plain meaning of Article 28, Sub-Article 1. My Lord, bearing in mind that that article cannot be derogated from, the question is whether in its plain meaning a court faced with the circumstances I have just described can be or even seen to be independent and impartial, particularly for purposes of trying those people who have lodged that complaint. My Lord, the place of the right to fair hearing is a sacrosanct place. We hold it in the highest possible esteem. It is the only thing that stands between absolute tyranny and the rights of an accused person. So, my Lord, there is a question we submit that has arisen in the context of Article 137 5 of the Constitution, this court is required, we submit, to refer that question. My Lord, permit me to read Article 137, 5. My Lord, it provides that where any question, Article 137, 5, just for completion, when that referral is done, the Constitutional Court's guidance on the interpretation of the Constitution must be waited for, must be awaited before the matter proceeds. But, my Lord, under the two paragraphs that I have cited, paragraph A grants this court a discretion. Paragraph B does not grant such a discretion and is mandatory in its terms. So, my Lord, the way that article is framed, the court in doing its work may find an issue and make a reference. But if any of the parties on whose behalf that work is being done asks it to refer, our submission is that the court must refer. And essentially what remains is the framing of the question. My Lord, if the question is referred, and the Constitutional Court agrees that Article 28(1) would be contravened, by proceeding in this matter, then the disposal of the matter would be in accordance with that view. On the other hand, insisting proceed with the matter in view of that question, and the Constitutional Court finds a violation, it would mean that the court is itself complicit in derogating from Article 28, 1 and 44C. So, my Lord, I would, before I sit down, also propose the question so that we can all be guided in its frame. So, my Lord, my proposal on the question, rather long, is whether the court presided over by a judicial officer against whom a complaint by the accused person in that court seeking removal of that judicial officer from office under Article 144 under Article 144 of the Constitution, is pending, essentially where the complaint is pending, is an independent and impartial court in accordance with the plain and ordinary meaning of Article 28(1) and Article 44(c) and is not a derogation therefrom. Lord, the question captures the issue that has arisen and the reason why it is now necessary to interpret Article 28(1). and 44(c). So, my Lord, it is my humble prayer particularly in view of the mandatory text of Article 137(5)(b), that the question as framed, as proposed, or an agreeable modification of the same be referred to the Constitutional Court. I so pray.
Basawo banyabo mbagala nnyo era mbaniriza ku Uganda Eyenkya. Nze muzzukulu wa Gamunga Moses Wamala ndi munnamawulire era ndafuubana nnyo okulanga buli munnayuganda afuna obwenkanya ssaako n'okufuna buli kimu nga bwe kigwanidde okubeera gamba ng'ebyobulamu ebyenjigiriza n'ebirala. Wabula mbaleetedde amawulire ag'essanyu era amalungi okuva mu Ohio Health Center. Lino nno ddwaliro eryazimbibwa emyezi 6 egiyise emabega. Ne mu myezi egyo ngenzo dirambulako ng'ebintu eby'enkizo ebikoleddwa biyitirivu nnyo gamba nga okuwa obuweereza n'obujjanjabi obw'obwereere eri abakadde b'eggwanga lyattu Uganda oba abakuliridde mu myaka. Abakadde abasobera ddala mu 300 be baweereddwa obujjanjabi, eddagala, okukeberebwa ssaako n'emmere eri ku mutindo okusinziira ku bulamu bwabwe eyo gye beetaagira ddala. Era kinsanyusiza ne kimpa akamwenyumwenyu n'essuubi. Wabula bakantemye nti mu myezi mitono nnyo kino kigenda kubeera nga kikoma olw'ensonga nti eddwaliro lino liri mu kazito oba lyetisse akazito ak'amaanyi ennyo ak'okubeera nga eddagala erina okujjanjaba abakadde bano, emmere, ebikozesebwa, emisaala gy'abasawo byonna bibali mu bulago. Eddwaliro terisobola kubikola bino byonna nga liyimiriddewo ku muntu omu. Tukkiriza nti bannayuganda ffenna nga twegasse wamu tusobola okuteeka akamwenyumwenyu ku bakadde ab'eggwanga lyattu Uganda okuwangaalira aba abawangaalira mu bitundu bino Mukono, Namataba, abava Lugazi n'ebitundu ebiriraanyeewo. Be nasanze olwaleero batindigga eŋŋendo empitirivu okujja okwefunira ku bujjanjabi obw'obwereere n'eddagala ery'obwereere. Wabula nzikiriza nti bwe tusaayo ffenna kye tulina ne tudonatinga oba okufundraisinga kyonna kye tulina tusobola okuyimirizaawo eddwaliro lino emyezi egirijja, emyaka egirijja okubeera nga lyetengerera okufuna obusobozi n'embavu okulabirira abakadde bano, okubawa eddagala lye beetaaga buli mwezi, okubakebera. Beetaaga ebyuma kalimagezi olumu ebibatawaanya bye beetaaga okuyingiza. Nzikiriza bangi abali eyo mu UK, mu America, Canada, abali e China, Belgium, Germany nawa. Eyinza okubaayo omuntu alina ekyuma oba eddagala lye wandyagadde okudonatinga eri eddwaliro lino erya Ohio Health Center ligende okujjanjaba abalwadde bano n'okubalabirira, okubabuddaabudda n'okubawa byonna. Sinakindi osobola okukozesa omukutu gwaffe ogwa GoFundMe okuwaayo ensimbi zonna z'olina. Osobola okukozesa mobile money ku namba y'essimu eyo, account number ku namba y'essimu eyo, Western Union, PayPal, MoneyGram. Ebyo osobola okubikola ng'okubidde oba ng'oyogerezeganyizaamuuko ne eddwaliro lino okumanya details ze weetaaga okusobola okuwaayo obweyamu bwo oba donation yo. $1, $2, $10, $5 zisobola okuwanirira eddwaliro lino n'abakadde okubawa akamwenyumwenyu mwanattu n'okwekkiririzaamu n'okubawa essuubi ssaako n'okusanyukira mu myaka gyabwe egy'obukadde nga balamu bulungi ate era nga basobola okukola ebyo byennyini ebigenda mu maaso okugasa eggwanga Uganda. Nkwebaza nnyo ng'owaayo donation yo oba obubaka bwo, obuyambi bwo obw'ebyuma, eddagala, emmere n'ebirala eri eddwaliro lino okusobola okutambuza omulimu guno ogw'obwannakyewa emyaka gyonna. Nze Moses Wamala nkwebaza nnyo okubeera nga okola ekyo ate era Mukama Katonda akunjagalire era akunkuumire ng'oweereza kyonna ky'olina okusobola okutuusa omulimu guno n'okugutwala mu maaso.
Uganda Eyenkya. Why don't you excuse my voice?
at all times uphold justice, so that even if there is favorable evidence that is favorable to the accused, a prosecutor ought to be able to present it to the court. And therefore, a prosecutor is not a persecutor. And therefore, a prosecutor should restrict themselves to ensuring that the process is fair to all the parties, including the accused persons. Therefore, very surprising to hear my learned junior stand to oppose an application for an interpretation of the Constitution on the right to fair trial. The prosecution, just like the defense, has no role in the interpretation of the Constitution. That's the preserve of the Constitutional Court. I would urge the court to disregard the gratuitous intervention of the prosecution itself to the need for the interpretation of the Constitution as to whether, just as put clearly by my colleague, the right to fair trial has been infringed by the circumstances before the court, mainly A1 and A2 have a petition to have your lordship, and one says justice is about perception. It needs not only to be done, but to be seen to be done. I repeat that judges are human, and you are human, my lord. And the perception of the man on the street will let be that justice can be obtained in this court, or right to fair trial has been infringed. Mine was just to comment on the prosecution. I see it.
My colleague from the state, because he did not object to the fact that what we are asking for comes out of a mandatory provision of the Constitution, namely 137(5)(b). So, my lord, I take it that we are in agreement with the text of the Constitution, that where a party seeks a reference the court shall refer. So I'm really grateful for that concession. The text is clear, and council is comfortable with our interpretation. My lord, to the view that the court must be satisfied that a question of law has arisen My Lord, we did propose the question it is a question of law. And again, my learned friend has not objected to that question, or that it is a question. My Lord, a trial before an impartial tribunal, or indeed one which may appear not to be impartial, is a serious, fundamental question of constitutional interpretation. If my Lord does what Article 137(5)(b requires, if my Lord does what Article 137(5)(b requires him to do, the Constitutional Court will, among other things, tell us what constitutes an independent and impartial court for purposes of Article 28(1). So we submit that there is a matter ripe, to use the words of my learned friend, ripe for interpretation. My Lord, the state has responded about the complaint before the Judicial Service Commission. And is a bit unhappy that it hasn't been served on them. My Lord, the complaint is not against the prosecution. Otherwise, complainants would also be acting against Article 28, but they are not. They cannot even deny its existence because the ruling of the court confirmed that indeed it exists, and the officers that are authorized to deal with it are dealing with it. So the attempt by the state to go against your Lordship's ruling this morning cannot be allowed to go unchallenged. My Lord, to the point that clients can file a petition directly before the Constitutional Court. That is indeed true. Not just to our clients, but to any other person in Uganda. However, the Constitution also provided, because that is in Article 137(1), the Constitution also provided avenues, other avenues. In 137(5). And my Lord, the distinguishing factor is that the question for interpretation of the Constitution arises in proceedings like this one. So, (137)(1) is available, so is 137(5). (137)(1) does not use the words shall in addressing the court, as 137(5) does. And my Lord, lastly on that point, there is no bar at all in a party choosing the most expedient avenue therefore, where proceedings are going on like this, 137(5) B is the most expedient option. The prosecution may not like it. It may be unhappy with it, but it's the Constitution. So, my Lord, my Lord, before I sit down, the matter that has been raised today, my Lord, is not about determination of the complaint before the JSC. It is related, but the specific problem my Lord, I say this with the utmost humility, is whether a judge who is a respondent in a complaint before the JSC can try to sit in a matter to determine the innocence of the persons complaining against that judge. Lord, that's the unfortunate question we have to deal with. And it is my humble request, my humble prayer that you accept to refer the question that, my Lord, we spend the next few minutes refining that question if it is required. The state has made no contribution to the phrasing of the question. So now, my Lord, between the court and those seeking the question, that we refine it if need be. Otherwise, the prayer is that it be referred in the format that it was presented to the Lordship.
The court pronounced itself thus: that the existence of a complaint in the JSC against a judge is not a bar to prosecution. My Lord, that's a general principle, because indeed a complaint may arise brought by A and yet the judicial officer is presiding over a matter against B. The issue here, my Lord, is that the court would be sitting in a matter where the...
Yes, can we agree? Whether you can try a country, looking at checking what there is thinking of this volume delivered either on the 5th or 6th. I want the convenient date for both parties so that I will make
the trend with which the court has production schemes that it adjusts for a week into the room. So, about 20 seconds.
The week is not available. I've looked at my phone. I'm also handling it. So, at least
Give us 25th
No, 5th.
5th or 6th?
Yes.
6th might be.
Any date from 5th, I have open. So we take 6th. This one is supposed to be at least on 6th. At 11 still. Now, next year, senior council.
Uganda Eyenkya.